Hafa day. Good afternoon, everyone. Thank you for being here. The Committee on Health, Tourism, Historic Preservation, Land and Justice is now called to order. Today's Thursday, January 9, and the time is 2:04 p.m. Public notice for this oversight hearing were disseminated via email to all senators and all main media broadcasting outlets on Thursday, January 2, 2020, and again on Tuesday, January 7, 2020. The notice was also published in the Guam Daily Post on Thursday, January 2, and again on Tuesday, January 7, 2020. We have just one agenda item for today, and that is an oversight hearing on the Chamorro Land Trust Commission and proposed changes to Chamorro Land Trust law requested by the Commission as part of a proposed settlement between the Attorney General of Guam on behalf of the Government of Guam, the Chamorro Land Trust Commission, and the United States Department of Justice in United States of America versus Government of Guam, Chamorro Land Trust Commission, and Administrative Director of the Chamorro Land Trust, District Court of Guam, Civil Case Number 17-00113. I'd like to acknowledge the presence of my colleagues today, Senator Mary Camacho Torres, Senator Kelly Marsh Taitano, Senator Clint Rigel, Senator Tello Taitagui. Thank you, colleagues, for being here. I'd also like to acknowledge the presence of Chairperson of the Chamorro Land Trust, Pika Farron, and Commissioner Tanamanda Santos. Thank you for being here. And the Director, Jack Hattick. Thank you for being here. And we are in the esteemed presence of attorneys, Assistant Attorney General, former Judge Jamie Canto, and Attorney Mike Phillips, Counsel for the Chamorro Land Trust Commission. Sizuz Masi for being here. Before we hear from the panel regarding the settlement, I just wanted to put on the record again, and I've done this in another hearing regarding the Chamorro Land Trust, but I want to put it on the record again, just a little bit of the background of the Chamorro Land Trust. The Chamorro Land Trust Commission is responsible for the disposition of Chamorro homelands, public lands, pursuant to mandates to advance the social, cultural, and economic development and well-being of the Chamorro people by way of residential, agricultural, and commercial land distribution and economic assistance programs. And these are provided for in statute. It is the Chamorro Land Trust Commission's mission to carry on any activities necessary to assist and inform the Chamorro community in obtaining maximum utilization of lands, including development of lands for their highest and best use in all phases of residential and agricultural leasing and commercial licensing. The late Senator Paul Bordallo, author of the Chamorro Land Trust Act, had the vision and fortitude and political will in 1975, which is to pass this law unanimously in the 12th Guam legislature. After passage and for many years, no governor would implement the act until the Nation Chamorro, under the leadership of Defuntu Senator Angel Santos, Defuntu Megalahi Ed Beneventi, and their wives, and others led an education and advocacy campaign urging the governor to implement the trust. The governor refused to implement, and a suit was filed by attorneys Mike Phillips, Mike Bordallo, and myself pro bono without fees on behalf of Angel Santos and the Nation Chamorro to force implementation. The AG argued at that time that the trust was unconstitutional. A hearing in the lawsuit was held while hundreds led a protest and camp out on the grounds of Adelup. A decision was made in 1992 by then Judge Benjamin Cruz that the law was valid and ordering the governor to implement the act and appoint the first commissioners. Several years later, in 1995, when Angel Santos was a senator, he introduced the rules and regulations for the trust, which were different than what the commissioners had originally written and controversial at that time. Again, he led hundreds in appearing at the legislature to urge lawmakers to adopt the rules, which they eventually did. With a few amendments over the years, the rules continue today. Last year, the Chamorro Land Trust and the island were shaken by the news of inconsistent treatment of applicants, non-collection of commercial lease payments, and other issues, as well as the lawsuit filed against the Chamorro Land Trust Commission by the United States Department of Justice for housing discrimination. These problems or issues that had been raised had forced the trustees and the Chamorro Land Trust staff, under the direction of the chair, Pika Farron, to put in many, many hours investigating, accounting, and finding solutions to the problems that were raised. And they continue to work on those today. We are We are here today after receiving from the Chamorro Land Trust Commission a letter from the Director, Jack Hattick, informing us of a resolution passed by the Chamorro Land Trust Commission, or the board, as it's commonly known, and urging our agreement to certain settlement terms. And so these have been passed out to the senators on the panel, and but we will begin with Assistant Attorney General Jamie Canto, on behalf of you representing the Attorney General of Guam here today. Are you representing the Attorney General of Guam here today? I'm assuming that you're here in your official capacity. Thank you.
Yes, Madam Chairwoman, thank you.
All right, and can you just state for the record again who you represent in this case?
We represent the government of Guam as well as the Administrative Director of the Chamorro Land Trust Commission, Mr. Haddock, who is present.
Thank you very much. All right. If you would give us, I guess you could state for the record what the status of the case is at this point.
The status of the case is, Madam Chairwoman, that the parties to the lawsuit have executed a term sheet which indicates an agreement to certain highlighted terms of what will eventually be a final settlement agreement. That settlement agreement has not quite yet been finalized. Some finer details are being worked out that we do not anticipate will have any great bearing upon the anticipated terms as expressed in the term sheet.
Might the agreement that you are continuing to work on add additional terms for the government of Guam?
It would for all parties, Madam Chairwoman, but as I said, it would not add or subtract anything substantial from what is expressed in the term sheet. Otherwise, the case is stayed pending the continued progression of the proposed settlement agreement, and we have a status hearing coming up at the end of the month with the settlement judge, Judge Barry Curran.
Oh, sorry, say that again?
A telephonic status conference with the settlement judge who was appointed in the case.
When is that?
It's, I believe, on the 29th of this month.
What is your understanding of what they are expecting from the government of Guam at that time?
The judge? What the judge is expecting?
Yes.
Just a status report of where things are.
Okay. All right. Then on behalf of the people of Guam or the government of Guam, do you agree to the terms that were transmitted to the legislature by the Chamorro Land Trust Commission? I saw your signature was on the document.
Yes.
And so you agree to those on behalf of the government of Guam?
The terms as expressed in the term sheet?
Yes.
Yes.
And is it your recommendation that the legislature should adopt those proposed changes to the law?
It is, Madam Chairwoman.
All right. Would you mind explaining the changes to the law
Well,
that are
as
being proposed?
I could go through the entire term sheet. Is that what Madam Chair would like me to do?
I think so, yes.
All right. The term sheet that was attached as an exhibit to the resolution that was promulgated by the Chamorro Land Trust Commission includes the anticipated possible amendment of the Chamorro Land Trust Act, starting with references in Chapter 75 of Title 21 that the terms Chamorro, Native Chamorro, and Chamorro homelands would be replaced with terms beneficiary, eligible beneficiary, and Chamorro Land Trust property, respectively, except that all references to the Chamorro Land Trust Act would remain. The Chamorro Land Trust Commission would still be called the Chamorro Land Trust Commission, and all other Terms as listed there, as in Hatin Amat Chamorro, Chamorro traditional healing or medicine, Chamorro heritage and culture, traditional Chamorro medicines, and traditional Chamorro remedies would not be affected. At section 75-101C, the settlement agreement would propose that that be revised. It's a definition of Chamorro homelands currently, I believe, and the term Chamorro land trust property would be defined as all Chamorro homelands under the control of the Chamorro Land Trust Commission under the provisions of section 75-105 of this chapter.
What is the practical effect of that change?
My understanding in terms of how the law reads currently, there would not be much practical effect. It's just that Chamorro Land Trust property is an operative term under the statute, which is necessary to be defined, and it was not previously defined. So Chamorro homelands, in terms of the proposed settlement generally, would continue to be acknowledged in terms of what the source of Chamorro Land Trust property was, that it was originally Chamorro homelands, that under the law as it exists currently, despite the settlement agreement, are lands that are available for use by the Chamorro Land Trust Commission to issue leases upon. In fact, there's 28 other references to the term Chamorro homelands in the act that would not be affected by the settlement agreement. So it's an attempt to try and acknowledge and recognize the history of these lands before they are transmuted into Chamorro Land Trust property.
All right. I note that the change that you're proposing to delete the term Chamorro homelands and the definition of Chamorro homelands will now be the term Chamorro Land Trust property makes reference then to 75105, which says, upon and after the enactment of this chapter, all available lands, and you want to change that to all available Chamorro homelands. Is Chamorro homelands defined in the bill? Or how will Chamorro homelands then be defined if this provision is removed?
Well, to answer the Madam Chair's first question, Chamorro homelands is currently defined at 75-101C, and it's somewhat circular. It yes. Currently states the term Chamorro homelands means all lands given the status of Chamorro homelands under the provisions of 75-105 of this chapter.
Yes, and then 75105 used to say all available lands shall assume the status of Chamorro homelands, but you're proposing to change it to be all available homelands shall assume the status of Chamorro Land Trust property.
Right. So there is no real definition of Chamorro homelands as it currently exists in the Act.
All right, we'll continue. If Chairperson Pica or Mr. Hattick or Attorney Phillips or Commissioner Santos, if you'd like to join in and while we go through an explanation of each provision. I'm sure the panel has many questions. I'll try to hold my questions until the end, until you're finished with the explanation. Yes, if I could.
If I may just add on to that discussion of why we're talking about Chamorro homelands and replacing it with Chamorro Land Trust property. The U.S. Department of Justice had an issue with maintaining Chamorro homelands as referring to the land trust inventory, because they expressed to us that keeping it Chamorro homelands makes it seem racist in nature, that only Chamorros can have these homelands. So we felt that this change would address their concerns while also allowing us to maintain the acknowledgement that these properties these properties are Chamorro homelands.
All right. If I may welcome, we have an additional commissioner here. If you like to join us, please.
This is Commissioner Joe Cruz.
Thank you, Mr. Cruz, for being here today.
A large number of the, if not all the terms that we're talking about now came about post-Davis. Before Davis, I think that the United States was very open. It didn't appear to me that, that we would have these changes. Post-Davis, they reserved the right to amend their agreement and consensus, and they exercised that right after Guam lost Davis. They took back, or they reviewed their offer, and they came down with these kind of qualifications, and they believed at the beginning, or at least they articulated at the beginning of the negotiations post-Davis, they would not accept anything that basically had Chamorro in it. They just thought Davis says that that's a pretext for race. And in Davis, it actually, in my opinion, says something quite contrary in footnote 18, excuse me. It leaves out the Chamorro Land Trust debate and issues and says they don't mean to opine on that. Well, that was our argument, but the United States didn't accept it, and so there was actually a compromise because they wanted more than that. So they allowed some terms to stay, and they would not accept certain terms. Those terms that they just would not accept are the terms now that you find. But that's really the reason behind it. They, I believe they kind of took advantage of the fact that they prevailed in Davis and with, I think, the input of some of the higher-ups, they felt that there needs to be a change. And so that caused a big problem for a while, and we did our very best to work through it.
All right. Mr. Canto, if you could continue with the terms of your settlement.
Thank you, Madam Chair, and also thank you for acknowledging the rest of the panel. This was a joint effort by myself on behalf of my clients, as well as Mr. Phillips on behalf of the Chamorro Land Trust Commission, and the chairwoman who's present as well. Section 75101D in paragraph 1C of the term sheet states that that section would be revised to state that the term eligible beneficiary would mean any person, regardless of race, color, or national origin, one whose land was acquired by the United States government between 1898 and 1968, or descendants of such person, or two, who occupied, farmed, or ranched land for residential or agricultural purposes for at least 1 year immediately prior to that land being acquired by the United States government between 1898 and 1968, except that a person is eligible if he or she occupied, farmed, or ranched the land on or after December 8, 1941, and the land was acquired at any time after that date and up to 1950, or descendants of such person.
Do I understand correctly, by this language, you intend to delete also the current language that reads, Native Chamorro means any person who became a U.S. citizen by virtue of the authority and enactment of the Organic Act of Guam, or descendants of such person?
It would, in fact, better articulate the intent of the Chamorro Land Trust Program as a land restoration program, and instead of basing the definition of an eligible applicant according to Organic Act citizenship, would, as proposed by the settlement agreement as written, pertain to those who actually had land taken or their descendants within an expanded period, even beyond 1950, when the Organic Act was enacted, to 1968, as well as expanding the class of eligible applicants to those who either occupied, farmed, or ranched the land for agricultural or residential purposes for at least a year, with the caveat of blackout periods that operate to their benefit, or their descendants as well.
Thank you. Before I go any further, I'd like to acknowledge the presence of Senator Sabina Perez. Thank you for being here. All right, we'll proceed. We'll come back for questions. Thank you.
I think we already covered paragraph 1D regarding section 75105 and the term Chamorro homelands.
Okay,
Paragraph 1E,
I'm just going to repeat on D. Okay, you're on 1E now. Wait, repeat that.
1E would add language to chapter 75, which refers to verification of eligible beneficiaries. And it states that, 1, regarding owned land acquired by the United States, to be eligible based on ownership of land that was acquired by the United States government between 1898 and 1968, a person must provide either A, documentary evidence of ownership in substantially the same form as that required by the Guam Ancestral Lands Commission for ancestral land claims, or B, a declaration or affidavit signed under penalty of perjury attesting that the person owned or is the descendant of someone who owned land that was acquired by the United States. It continues, to the extent known or reasonably ascertainable by the person, this declaration or affidavit shall include the location by parcel number, address, legal description, or other legally recognized identifier of the land that was claimed to have been owned and the date of acquisition by the United States. The applicant shall be required to use their best efforts to obtain the information described above. The applicant must also provide documentation demonstrating that they are the descendant of the person who owned the land. And based upon the review of the documentation, declarations, or affidavits, and any additional research the Commission conducts, including but not limited to the bond files and any other readily available condemnation and land records, the Commission shall determine whether the applicant is an eligible beneficiary. Shall I continue, or are there any questions, Madam Chair?
Continue, please.
Certainly. The Roman numeral 2 regarding verification of eligible beneficiaries applies to those who occupied, ranched, or farmed land acquired by the United States as opposed to owning it. And it states, persons shall be considered eligible beneficiaries if the United States acquired land on which they did not hold title or ownership, but who nevertheless had occupied, ranched, or farmed land for a continuous, substantial period of time as of the date of acquisition by the United States, except that a person is eligible if he or she occupied, farmed, or ranched the land on or after December 8, 1941, and the land was acquired at any time after that date and up to 1950. To be eligible under this provision, an applicant must sign a declaration or affidavit setting forth in sufficient detail and under penalty of perjury the following facts to the extent known or reasonably ascertainable by the applicant. 1, the location by parcel number, address, legal description, or other legally recognized identifier of the land that was claimed to have been occupied, ranched, or farmed. 2, the name of the person or persons who occupied, ranched, or farmed the land. 3, the length of time the person or persons continuously occupied, ranched, or farmed the land. 4, the legal owner of the land and the relationship between the owner and the person who occupied, ranched, or farmed the land, including whether any compensation or rent was paid to the owner. 5, a description of the nature of the person's activity on the land, including whether the land was used for residential or agricultural purposes. 6, if the land was ranched or farmed, the type of activity being conducted on the land, such as the types of crops harvested or animals raised. And 7, whether the person improved the land in any way and the nature of such improvements. The applicant must also provide documentation demonstrating that they are the descendants of the person or persons who occupied, ranched, or farmed the land. The applicant shall be required to use their best efforts to obtain the information described above. Based upon review of the documentation, declarations, or affidavits, and any additional research the Commission conducts, the Commission shall determine whether the person is an eligible beneficiary. It continues to state, for purposes of this provision, a substantial period of time, and that's referring to the amount of time for which a person should occupy, farm, or ranch the land to be eligible, or their descendant to be eligible. A substantial period of time shall be no less than 1 year, and a person shall be deemed to have occupied land if he or she maintained his or her primary residence on the land. And that's 1E.
All right, this is we are now, I'm going to just try to restate that, but you are welcome to please restate it. But because we're trying to get the public who are listening to also follow along, they don't have these documents in front of them, but we are now going to require that eligible beneficiaries be verified, and they have to have either been an owner of the land or a descendant of an owner of the land, and there's a very detailed process of how you show that, and an affidavit is one of the ways that you can show that you owned that land or your family owned that land. Or you are a descendant of a person who occupied, ranched, or farmed the land, and all of these require that you owned or occupied land or used land that was later acquired by the United States. Is that correct?
Yes.
All right, and then you have a very, again, extensive list of criteria that they must meet, those 7 items that you listed.
To the best of their ability.
Yeah, and that they must prove all
Their
of
best
those.
effort.
It says
No.
and?
No, just their
or?
best effort, Madam
Best
Chair.
effort, okay, great.
No proof required on their part.
Madam Chair, if I may.
This one
in,
again allows an affidavit to
Right.
say that these things are correct or true about you or you are a descendant of these people.
As many of them as they are aware of, as
Okay.
it states.
All right, Mr. Phillips.
Yeah, 2 things very quickly, Madam Chair. I think the Commission will be able to template and kind of boilerplate that as a checklist, and they can help the applicant go down to see. I believe just about everybody that was here would qualify. It does 2 things. One is it expands
Everybody that was
on Guam.
on Guam,
Yeah.
when?
From 1898, and that went through what the United States did, the taking of the land and all that. When I say was here for that experience. Earlier, it was close to it, but it was pegged on citizenship.
Correct.
And that was not the origin of the law. The law was very close to a carbon copy of the Hawaiian Homes Commission Act, and it remained that way until about 1980. But towards the end of the 70s and in about 1980 became clear, I think, to the legislature, and through Dick Taitano, the late Senator Dick Taitano, he amended the definition, and I believe that allowed the act to withstand constitutional challenge for at least another 3 decades. And so we're at a point now where that definition no longer, or it allows the act to become very vulnerable. And again, it doesn't really change the scope of the act except to expand the beneficiaries. But I believe that this definition is what's key, and it's a land restoration. And during the negotiations, we introduced to the United States the concept of land use rights. And Chamorros and people from Guam had done that for decades and decades and decades. And each time it's introduced, it's interesting, but it's never been accepted. This is the first time that I'm aware of that they've actually accepted the idea that whether somebody from Guam owned the property or not, they were harmed just as much, sometimes more. And so whether the individual owned the property or not is not key. If you owned it, of course you qualify. If you don't, as long as you lived there, you occupied it, or you ranched it, or you farmed it, whatever the case may be, when you, for example, as a landowner, lost your property, and the person that was actually farming it is not included in history, so to speak, they actually were harmed, sometimes more. And so this takes care of all of that. It includes all our military personnel, all those that were enlisted in the military and received their citizenship in that manner were not included in the citizenship test because they received their citizenship in a different way. But it didn't mean that they had not gone through this experience. Quite frankly, it didn't even mean they weren't Chamorro, but technically they weren't under that definition. Secondly, the people that may not have been on Guam in 1950, but experienced everything from, or a portion of it from 1898 through 1950 at least, were also excluded and are now included. And the reason I believe you have this detail is because we're negotiating with people that I think admittedly have not really experienced this. This is not something that's normal on the mainland. It's not normal, it doesn't happen. And so they're saying, well, if this is true, then these are the things that they kind of want to see. So that was kind of the compromise. For people on Guam, land use is not a foreign concept, but for a lot of people that are not from Guam, land use is a very strange concept. The idea that people use land and don't pay for it, there's no sharecropping, you pay the taxes, there's no rent paid. That was really foreign to a lot of people. So the compromise is, well, here's the list of things that we want to see to make sure that that's really the case. I believe, though, it will cover everybody that went through that experience, very, very different from the citizenship test.
If I may also
Yes,
add
please,
how
Chairperson.
these two new eligibility criteria would, I guess, take effect in the program as it is today. So current leaseholders, if you have a lease already, you will be untouched, okay? You don't have to worry about these eligibility criteria. However, your successor to your lease will have to prove their eligibility under the program under these two, whether you owned it or used it. So if you, so the successors would have to go through these two eligibility criteria in order to be identified to receive the lease upon the leaseholder's death. If you are on our waiting list, you will have to...
Sorry, your what list?
Our waiting list for residential and agricultural leases. If you are on our waiting list, you will need to go through these two eligibility criteria prior to receiving a lease, okay? And then new applicants into the program will also have to go through these two new eligibility criteria. You know, it's a lot of words and a lot of like different things that information that the law is asking of these individuals, and it seems difficult. But as Attorney Phillips mentioned, the trust and the commission will set it up so that there's kind of like a boilerplate form to be filled out for these affidavits, but it really is up to the individual to go out and get that information for themselves. And, you know, I'm imagining individuals, you know, now being forced to sit down with their Sainas and their family and really learn about their family history and how their family was really tied to this land. So.
I note, Chairperson Farron, that in your press release, you start off with these two you described the favorable terms to preserve the CLT program intact, including our current leaseholders. And so then you've explained that right now, that the current leaseholders are untouched by these two qualifications or eligibility criteria, but those on the waiting list, this will apply to, and any new applicants. And then you said also, it admits our island's history and more clearly demonstrates that the CLT program is a land restoration program meant to rectify the unjust taking of Chamorro homelands by the U.S. federal government between 1898 and 1968. And so that's why those dates are included in here, and Mr. Phillips explained land restoration program and the unjust taking. He said this is intended to remedy. And you also explained not just ownership, but the occupied, ranch, or farmed land, that those are also criteria as...
Madam Chair, the common term we've used is land use rights.
Okay.
But for purposes of the settlement, those are the terms that, the operative terms are there, but in general, we call that, we had land use rights. So people were able to use the land. But that didn't seem to work as clear in the settlement. So those are the terms that you have. So in defining, well, what does that mean? Those are the terms that we agreed to. You lived there, you occupied it, you ranched it, you farmed it, and they felt that, well, if you did it for 1 year, then that qualifies. So that's how that came about.
Can either of you explain that in a little bit more, the history of land use rights on Guam as opposed to land ownership?
It was really the Chamorro Land Trust program. I know some people used to ask, why don't you just give the property away? Because that's just not the way it was. I mean, the whole point is property or land is finite, and what you were guaranteed is land use rights. There was no market. Guam was closed to maybe 1960. I believe it was President Kennedy, so it could have even been 1961 that it was open. So there wasn't a buy and sell, though that happened. It wasn't for market value or anything like that. The United States has a horrible history from 1898 to at least 1950 and on of taking property in all kinds of ways. And so that's how the word acquired, I think, came up as maybe a euphemism or summary of the many, many ways that they acquired Chamorro homelands. One way, one of the more popular ways, is what the late Senator Dick Taitano termed crown landization. When they came, they actually expected to find a whole bunch of crown land, and didn't find much crown land. And so they created crown land by requiring Chamorros to register all their property and pay taxes. Of course, there wasn't much, it wasn't a cash economy, there wasn't money, and so the Chamorros did one of two things. They either registered all their property and lost it, or they registered a portion of it, which I believe most of them did, and then they, in essence, ended up losing the balance that they didn't register because the United States considered that crown land. Must be crown land. If you don't own it, then the crown owns it. And if the crown owns it, we own it. And so the United States acquired, another method of acquiring property, for example, was that method.
When you said they would either register all their property and lose it, what do you mean by that?
Because they didn't have money to, the people that had sizable property would not have been able to pay the required taxes that were imposed. Because one of the first orders was to impose taxes on land. And that just was not the practice here. And so you don't have that economy. And in terms of buying and selling, there was internal exchange. And if you call that a market, I guess you can, but there was no external, there was no freedom in the sense that the property was worth anything, but you were taxed as if it was. And so without the cash, like I said, there's probably other choices that were made, but the majority of the choices were either register a portion of it and you struggle to pay taxes on that, or you register the whole thing and you lose it. And so that's why there may be other places. I'm not familiar with any other place, but on Guam you still have land registration. People get to go in and say, as I have with my clients, that I remember my aunt and my uncle telling me that that's the property we own, and nobody objects. Someone's got to own that property. You end up having that property registered in your name if you go through court and you go through those proceedings, because they understand the unique history of Guam. That land was taken. Maybe an easier way to understand it is the government of Guam has tens of thousands of acres, right? But there was no government of Guam until 1950. So you ask, well, where did you get that property? They didn't go out and buy it, right? The United States gave it to them. But the United States didn't go and buy that property either. The United States took that property from the people of Guam from 1898 all through the time that they conveyed it to the government of Guam, which was actually around 1952. And so rather than list all the different ways in which the people were losing their property to the United States, and then that property is all given to the government of Guam, that term acquired was used. And so the land restoration is kind of the operative term that summarizes both. And it allows the act to continue because currently there is no legal prohibition to land restoration. And so here it's land restoration of land use rights. It's not giving land back and it being a fee simple, but it's land use rights. As far as the program, I believe it has the same intent that the program had when it was drafted in '74 and became law in '75, and that is to ensure in perpetuity that those land use rights continue. And that's what I believe that it does. Of course, now we look at the program more as a land restoration program. And with that, it's insulated for, I think quite some time from constitutional challenge.
Could you discuss why land, not just land ownership, but also land use was recognized in this negotiation?
In this case?
Yes, and what types of land use are you describing here?
Well, the manner in which the role that land played back then, there were a few businesses, obviously people own land, but it was either owned or used. And I'm sure there was land that was owned that was not used, but again, the people that used the land didn't necessarily own it. And the reason I talk about Guam being closed and there's no market is this. It's kind of like, not exactly like this, but it's like air and water, Who would ever think you're going to start selling water? So back in the day, people were not real concerned about, I've told people, my ancestors had property, but I don't have a single deed. I wouldn't be able to tell you the lot number or anything. It's just, it's of no concern. And it wasn't the concern back then that you have to own the land in order to farm it. The people raised generations of families without technically owning the property. But the way that they were able to provide for their families is by working, by farming. The ownership of the land means a lot today, especially in Western communities. The land itself, without doing anything, has value, but not before. You have to work it. And so that's what was done back then. You work the property, and as was testified to Congress in 1936, what the individual makes off the sweat of his brow is his. He didn't pay rent, he didn't pay taxes, there was no sharecropping. That's the way it was. And people didn't find that foreign at all. That was the practice. There was more than enough land for people to work and farm, and those that worked and farmed, traded, and that's kind of how life was. To preserve those land use rights, I believe the Chamorro Land Trust was created, and this is very consistent with that. If we were to just go on land ownership, it would be a disservice to so many people that one, probably couldn't prove it, but number two, that just wasn't an operative part of working the land. Now it is. If I showed up on your land and just started to till away and farm, you'd say, "What are you doing? That's my land." But that wasn't the case for up until those drastic changes were made by the United States and converted that practice and that culture into something very, very different. But up until that point, everybody was able to work the land, and those that worked the land produced, and those that produced provided for families, and that's the way it was. And so I was pleasantly surprised that the United States accepted it. They wanted proof. They read it, and they appeared convinced that you're right, that's the way things were. And so it still remains a land restoration program, even when you're returning those land use rights to people that didn't own the property. It's still the restoration of land use, because they lost that right of land use. It was just as much a loss to them as if they had owned the property. So it was a big concern of the commission and everybody involved that the two were treated equally. Because at one point they thought, well, that would be number two, and we had argued, and the commission felt strong that through the chair, Pika Farron, that they be treated equally. And so the final terms are that it doesn't matter whether you owned or used, or your ancestor did, those two methods of being eligible for land use rights are equal and the same.
Thank you. I want to thank you for ensuring that land use rights were included in these negotiated terms. All right, if you may proceed, if you would proceed, Mr. Canto.
Certainly, Madam Chair, and I also want to take the opportunity to correct any possible misconceptions. I think, Senator, you're referring this as to my settlement agreement or what I want to see happen. The fact is we all do. All the parties present at this table, save for the commission members and the administrative director, were present at the settlement negotiations. And this was a product arrived at between all the parties to the lawsuit. And I am just one attorney to two of the parties. So I'm glad that the chair is asking for Mr. Phillips' input, because he was instrumental into making this happen in some ways that I think are highly beneficial to the program. as well as the chairwoman of the Chamorro Land Trust Commission, who was present and also highly instrumental in making sure that we reached what we jointly believe is the best resolution of the matter. But with that, I'm happy to continue reading the term sheet.
Mr. Canto, just I want to clarify also, the reason why I'm asking you those questions particularly is because you are representing the Attorney General of Guam, who is the only lawyer in this room who represents the people of Guam. So on behalf of the people of Guam, I want to know whether we've already got written confirmation from the Chamorro Land Trust Commission by resolution that they endorse this, they want this. But I want to know for sure on the record whether the Attorney General of Guam wants this for the people of Guam.
And we do represent the government of Guam, which is a larger set to the subset of the actual parties who administer the program, that being the Chamorro Land Trust Commission and the administrative director. So the people of Guam are not a party to the case. The government of Guam is, and only insofar as the agency and the agency director are administering the program. And that was the program itself that came under fire.
But it wasn't just the Chamorro Land Trust that was sued, it was the government of Guam,
Correct.
Right, so it's much larger than the Chamorro Land Trust Commission. They couldn't settle it by themselves. It's the entire government of Guam that is going to settle this case. That's why the legislature's involved at this point. I'm taking it. It's because now you want the entire government of Guam to change its laws and to go along with the settlement, to say yes, that we all want that settlement, right? Yeah, not just the trust, because the trust, we've heard from the trust. But they're not the only parties. The government of Guam, like you say, I always equate the government of Guam to the people of Guam, and that's because I just feel that we're not anything if we're not going to be representing them. So, and lawmakers are not involved in that process. You are resolving this for the entire government of Guam without our input in your settlement negotiations. So that's why I need to ask. So thank you. Yeah.
I understand.
Please proceed. Yeah.
The next section, section 1F, on page 3, Madam Chair, states that section 75-109A's third sentence would be revised to state, quote, such person or persons must be qualified to be a lessee of Chamorro Land Trust lands, provided that such person or persons need not be 18 years of age, provided further, however, that if the person designated by the lessee, 1, is the lessee's spouse, 2, has been married to the lessee for at least the past 7 years, 3, is residing on the property with the lessee in a structure that has been approved as a residence at the time of the lessee's death, and 4, is not an eligible beneficiary as defined under this act, such person shall, upon the death of the lessee, receive a life estate and the remainder of the lease, and upon termination of the life estate, assignment of the lessee's remaining interest in the lease shall be governed by the applicable provisions of the Chamorro Land Trust Act as if the lessee had died without designating that person as a beneficiary. In other words, Madam Chair, the property would revert back to the Chamorro Land Trust.
All right, now this language that you read out is going to be added to a current provision that will remain in pretty much intact that talks about upon the death of the lessee, they can designate who will take over the lease. So this now adds that in addition to designating somebody, they must, if the person designated is not eligible, that's the big difference here?
Yes.
Good. All right. Then you're making it's like an exception, I guess. Is that correct?
Essentially.
Yeah, all right. And so
A very limited one.
a limited life estate to a spouse if no one was designated as beneficiary. Is that correct?
Madam Chair, they would be now allowed to designate
Spouse.
A spouse under those conditions that
Okay.
otherwise did not qualify.
I get
Nobody else other than that. But yeah, it's a substantial change, but it is limited.
All right. But everyone else who will be can be designated must
have
be
to qualify.
eligible.
That's
All
correct.
right.
Correct.
Okay, all right, please proceed.
So just to clarify, Madam Chair, it must be a spouse of 7 or more years.
Okay,
There must be an approved residence on the property, meaning ostensibly there's an occupation permit, an occupancy permit, excuse me, and it must be the primary residence of the spouse as well. The Section 1G, according to the term sheet we reached, says that any applications for leases that are considered after the effective date of this agreement shall be subject to the terms of the agreement, which alludes to what Chairwoman Farron stated earlier. As you well know, none of the 3,000 families who currently hold Chamorro Land Trust leases would be affected or would experience any change as a result of the proposed settlement agreement. The second sentence in paragraph 1G states that this agreement shall not affect the order of consideration of applications. And that refers to those who are currently on the waiting list. Their place in line would not be affected. Shall I continue?
please.
Paragraph number 2 on page 3 states that defendants shall make reasonable efforts to notify current lessees and applicants of the provisions described above, including posting such changes on the Commission's website. Paragraph number 3 on page 3 states, within 180 days of the effective date of this agreement, the Commissioners, Administrative Director, and employees of the Chamorro Land Trust Commission shall attend, at defendant's expense, an in-person education and training program on the requirements of the Fair Housing Act, including discrimination based on race, color, or national origin. The training shall be conducted by a qualified person approved in advance by the United States.
Proceed. Thank you, please proceed.
The next page of the term sheet, page 4, at paragraph 4, states, the duration of this agreement shall be for a period of 4 years. During this period, defendants shall maintain all records with respect to compliance with this agreement. The United States shall have the right, upon reasonable notice, to review and copy any such records and to take any action to enforce this agreement as authorized by law.
I have a lot of questions about that 4-year, but we'll come back to it. Thank you.
Okay. Paragraph 5 states, the parties understand and agree that this agreement is contingent upon the enactment of legislation by the Guam legislature, including amendments to the Chamorro Land Trust Act that are substantially in the same form as the terms of this agreement. Defendants shall make diligent efforts to seek enactment of any legislation necessary to comply with and carry out the terms of this agreement. If, within 1 year of the effective date of this agreement, defendants fail to obtain enactment necessary to comply with this agreement, the United States retains all rights, including the right to withdraw consent to this agreement and revive all claims otherwise barred by operation of this agreement. Within 90 days of the effective date of this agreement, defendants shall additionally determine whether and to what extent to which this agreement may be implemented through executive or commission action, and shall do so where authorized by law.
Thank you, please proceed.
The final paragraph on page 4 of the term sheet, paragraph number 6, states, the parties recognize that as a term of this agreement, the United States shall file a motion with the court to vacate the portions of its December 21st, 2018 and April 25th, 2019 orders holding that the United States is barred from obtaining damages on behalf of aggrieved persons under the Fair Housing Act in this case, and that defendants shall not oppose this motion. Nothing in this provision shall authorize the United States to seek damages in this case. And that's the extent of it.
All right, thank you. Is there any other term that you are aware of as of this date that's not included here?
Any material term? No, Madam Chair.
Thank you. All right, is there any explanation that anyone else wants to add before we open it up for questions? Mr. Hattick? Mr. Chairperson Pika, Farron? Oh, I'm asking, so he's gone through the term sheet. And before I open it up for questions on these terms, I wanted to know if any of you wanted to add any other, just add anything else to these terms or description of the terms. All right. All right, appreciate your work in this, and I guess I'll open it up now. Let me just go through the terms then, as you've listed them. So we'll begin with the first term, if there are any questions of the panel? Or are there any questions in general before we go through the details? Any of the senators? Senator Rigel.
Thank you, Madam Chair. Just, I guess, to clarify, sure members of the public might be interested in understanding these terms, specifically with regards to eligibility. So currently, the eligibility requirements are just anyone who was made a U.S. citizen by virtue of the Organic Act and their descendants, correct?
The pursuant to the authority and the enactment, because the people of Guam went through that very, very, very unique experience of becoming citizens through the stroke of a pen. And so that's enactment. The authority of the Organic Act obviously includes descendants, but there's only a small group of people that have experienced that. So that's the uniqueness of the people back then. So it's the authority, pursuant to the authority and the enactment.
Okay, okay. So this would change the eligibility, though, to anyone who can show that they've owned or occupied or ranched any property that was ultimately taken by the U.S. federal government, correct?
Yes, owned or land use.
Or land use, that's the term,
The
land
two general
use.
categories, yes.
So my main question with that, I guess, and I'm sure a lot of people are curious, and you kind of touched on it earlier, you felt that this would sort of encompass more people, right? So I guess my question is there any possibility that, say, someone who's currently on the waiting list for this property, that they could get excluded because of the new eligibility requirements?
I think there's definitely a possibility, but I haven't I haven't heard from anybody that otherwise would not qualify, and I haven't yet heard a scenario, and there's got to be something, but I haven't heard one that would show that, for example, Juan Cruz that otherwise would qualify no longer qualifies. And I do know the 2 or 3 other subsets of the people of Guam that now qualify that were arbitrarily excluded because the act needed to be insulated from a constitutional challenge, and it was. It used to, from 75 through 1980, it was like the Hawaiian Homes Commission Act was a blood test, and that was fine then. It didn't become acceptable later, and so that was changed to what really was an arbitrary definition that worked very, very well, and now that no longer works, and the act remains vulnerable, and so land restoration is likely the most safe under current law and the current makeup of the Supreme Court, and so that's where we are. While that definition worked, I think the 3 definitions, this being the third, the proposed definition, come close to defining the people at that time. The interim one, I would argue, is the one that was most arbitrary. Those that happened to be here in 1950, while the majority of the population went through that, not everybody did, and those that were excluded really were excluded without reason. There was nobody's choice to become a citizen, and yet so many people were excluded because of that. Only those people were included, but it did encompass the majority of the people that were here. This broadens it, but to answer your question directly, I'm sure there's got to be somebody, but I haven't been able to figure out how somebody who has that ancestry could not show to the extent needed to receive a lease by the commission that they had some form of land use rights. That remember, the ancestry now doesn't go to 1950, it can go past, and so quite frankly, if I was old enough and you were my dad and you didn't qualify, maybe my grandfather did, maybe my great-grandfather did, so I'm a descendant of somebody that does qualify. And so when you use that and that's an overlay, I think that is almost certain to take care of everybody. But your question is there a possibility? And yes, there is.
Okay, thanks. So, well, that's, I guess, in terms of anything's possible, right? But
Yes.
I guess maybe let me rephrase it. What's the likelihood then? I don't know if you can answer.
I think it's very unlikely. Yeah, because of the overlay. Now the ancestry is not limited to 1950. If you're a descendant of somebody that had that situation all the way back to 1898, you qualify.
Okay, thank you.
Senator Kelly Marsh. We are on general questions now, and we'll get into the specific terms in a minute.
Sujus Masi, Madam Chair, and Sujus Masi to all of you for coming here today. I know it takes a lot of time and effort to do so, and I really appreciate it, and I think the community of Guam appreciates it very much as well. So we've heard discussion about this time and that, and during previous oversight hearings where you have assessed that it makes the Chamorro Land Trust stronger, it maintains its integrity, and things like that, which is very good to hear. That's very important for us to be hearing. In looking at all of the changes overall, would you say that there is anything that has strengthened or simplified the processes for qualifying, or just the different processes that are involved? Do you feel that they've been strengthened or simplified in any sort of a way?
Thank you for your question. You know, I actually don't think that it's been simplified. In fact, I think it's going to take a lot of effort on the administrative part to implement these new qualification criteria. But I don't think it's insurmountable. I think once we figure that out, we'll be able to administer it. We're going to get those strong standard operating procedures in place so that there's no question. But I think in regards to this statement that this makes the program stronger, I think the new definitions for what makes you an eligible beneficiary, it makes it very clear that the Chamorro Land Trust Act and the program that we are implementing is a land restoration program, and it is not rooted in any racial discrimination. You know, I've served on the commission almost 4 years, and prior to my serving on the commission, you know, I would, you know, just reading the act and kind of trying to understand what it was, it seemed like you had to be ethnically, racially Chamorro in order to qualify for these leases. However, as soon as I jumped into the program and I actually read the law and I saw how the law was being implemented, it was very clear that that was absolutely not the case. As we just discussed, in order to be eligible for the program, you would have to prove that you or you're a descendant of somebody who gained U.S. citizenship in 1950 with the Organic Act. And we know it was not just racial or ethnic Chamorros here on Guam that received that U.S. citizenship. But I believe that these new eligibility definitions make it clearer that this program is not racially based.
Sujus Masi Pere'ena. And with that discussion of it providing that additional clarity and taking away perhaps some of the uncertainty, so I was weighing in my mind that even though there may be a few more steps in certain ways, that perhaps strengthens the process by taking away some of the uncertainty, some of the worries about it being challenged or something like that. So I'll go ahead and think of it that way so that I can think of it being perhaps strengthened.
Yes,
yeah.
precisely. Thank you.
Senator Taitagui.
Thank you, Madam Chair. Jamie, could you explain to me on page 4, number 6, can you kind of give me a full explanation of this? It's very confusing. And if you could just, per line, kind of explain it through so I
Certainly.
can understand it?
It does not just, thank you, Senator, and just for your understanding, it's not a provision that affects the operation of the Chamorro Land Trust program at all.
Okay.
It's simply an aspect of the legal proceedings of the case. And what had happened was we had prevailed against a partial motion for judgment of the pleadings that was brought by the United States in the case. And there was an adverse ruling against them by Judge Mulway regarding their ability to exact or levy civil penalties on behalf of an aggrieved person who may have filed a complaint under the Fair Housing Act. And this would ask for our non-opposition to their motion to the judge to reverse just that part of the order that's in place of the case. Doesn't mean the judge will grant that motion for them. We don't believe that there is any extensive bearing upon the continued operation of the program. It's part of the legal proceedings. I don't know if that helps.
So basically, in layman's terms, as long as this party does not object to any of the motions made by the other side, then that's basically what it is, that you don't object at all to their motion. And
Just
it's
that
very
one
simple,
motion.
that particular.
And
And when
Senator,
it says,
if
Yeah,
I
go
may,
ahead.
the commission benefited greatly because of that victory. There are two parts to that decision. We won both. The argument by the United States was on its face, the law violates the Constitution, and they lost. But where it could really hurt in the pocketbook, right, especially with the government, was if we, in rolling the dice, would face financial penalties. And former Assistant Attorney General Ken Orcutt did all the work on that, and he prevailed. And that was a huge win, because even if we lost, at least as the ruling went preliminarily, and it looked really solid, and in my opinion, it was going to stick. Guam did not face financial penalties. In the United States, they believe they need that when they go from jurisdiction to jurisdiction, and they're doing what they do. That was, I think, a real surprise for them. And so Jamie's correct. It doesn't affect us at all here. But where it did affect us is it allowed us to probably receive concessions we otherwise would not have received, but for that victory, because Ken won that. They were willing to concede areas that they otherwise wouldn't, under the condition that we concede that they be allowed to ask the judge, and we don't object to having that changed.
Okay, thank you so much.
It was a big blow for them, and they need that changed.
Thank you so much, and thank you, Madam Chair.
All right, because we're on this provision instead of a general question, is there any other question on this provision? We're talking about term number 6. Yeah, I found this very interesting, that the parts of the case that we actually had prevailed in or won are the ones that we are now going to be agreeing to vacate or dismiss and allow. Does that mean that they will now be allowed to recover damages?
No.
Because the court had barred them from recovering damages.
No, not if the settlement agreement goes forward, and even if it doesn't, because our only conceding to a non-opposition would be as a result of the settlement agreement. Then there wouldn't be any change. We would still have that ruling in our favor.
There are not other claims that could be brought seeking damages that would be impacted by this waiver or vacating?
We would argue no. That was an argued point during negotiations, whether it could be used against us later in some other case. And the understanding of all parties at the end of it was that that could not happen legally.
All right, any
Mike,
other?
do you?
Yeah, we're not barred from raising that. To quote Senator Wright, anything's possible, but it doesn't seem to affect us at all because it's part of the agreement. If the agreement goes, then so does that.
All right, any other questions on this term, number 6? All right. Okay, so if you don't mind, I'm going to start again in the beginning and ask for questions. So the first one is the terms, references to Chamorro and Native Chamorro, replaced with beneficiary, eligible beneficiary. Any questions on that provision? All right, on the second one, this is the more substantive one where we change the definition of Chamorro homelands, and we use now Chamorro Land Trust property means all Chamorro homelands under 75105. If I could just raise again, Mr. Canto, if you go to 75105, I'm concerned that you are removing in 75105 where it used to say all available lands are Chamorro homelands, which, you know, we know the history of this available lands. That's everything the government owned at certain point in the law. They said everything the government owns that is not used
Reserved,
or
right.
designated for use is now in the inventory of the Chamorro Land Trust. Does this impact, by taking away the words available lands and replacing it with available Chamorro homelands, assume the status of Chamorro Land Trust property, does that limit your inventory? Are you no longer entitled to available government of Guam property?
Madam Chair, there's no intent to change that entitlement. The intent here actually started off with a debate with regard to whether there would be a cap. And the initial proposal by the United States was to cap without much reasoning. And so we argued against it, and it may have taken a little while, but not too much time before they reversed, and they said, okay, no cap. And this is what you have left. In fact, and maybe it's important for people to know, I would say that, and Jamie was there for a large part of the negotiations, he can give you his opinion with regard to how we did, but I would say somewhere between 4 and 5 out of 7 provisions went our way, easily 4, more likely 5. And so what we have here, and don't get me wrong, I can understand discomfort, so I'm going through this, there's a little discomfort here too. But the reason I find comfort is because of all the different provisions we were able to win on that were actually all on the table. There's great objection to many provisions in the Act, and a complete elimination of many of these that we were either, one, able to completely take off the table, which you don't find here, which is a victory for the Commission. And then number 2, those that you do find, these were not the original provisions or proposals. They talked about straight out elimination, and we were able to save, like I said, I think easily 4 or 5 out of every 7 areas that we negotiated. Team Guam prevailed, and we did very, very well. And I personally attribute a lot of that to Ken Orcutt's work on the financial side of the lawsuit, because when he won that, he really caused them to say, well, in my opinion, that they were willing to give a lot in order to get rid of that.
Gave you some great bargaining power.
Absolutely, yeah.
Thank you. Thank you to Mr. Orcutt. All right, and so on this section, any other questions or comments? On this one, yes.
So connected to this, if I'm reading D correctly, I think it seems to me, right, but we were on B, but it seems to me that D, in the revision there, that it addresses the discussion you were just having, where it's revising it to state, upon and after the enactment of this chapter, all available Chamorro homelands shall immediately assume the status of Chamorro Land Trust property and shall be under the control of. So when they have that term, all available Chamorro homelands, does that fit that same definition essentially that had been there before?
Yeah, the intent was strictly, the concern was homeland. They felt that, well, if it's a land restoration program, are you giving the appearance to people that it's reserved for a certain select group, and it's not. And since it's not, there shouldn't be any objection to calling it this. And so recognizing the history and allowing that to stay, but then converting it, really it's intended, or they felt very strongly about it, don't get me wrong, but it's just the term itself, they felt much more comfortable with changing the term. And that's it.
Okay, so with the available lands that the chairwoman was speaking of, that used to be there in the language as all available government lands. So is that all available Chamorro homelands? Is that available, continuing that same concept, but just with this new terminology?
Yeah, I think we're talking about the current property there, because it is termed Chamorro homelands. That now that term will be changed. And honestly, I defer to Jamie if the land comes in. Is it under Chamorro homelands and then converted, or is it just converted? I don't know the answer to it. But just so I don't forget, Senator, because the chair mentioned the 10 or 11,000 acres. The commission was actually entitled to over 20,000 when the law was passed, and I remember because I was part of that. And I remember it was during the Ad administration. They said, "Don't worry, we'll convey half right away, and we'll convey that other half soon." And it's never been my business. I haven't been involved in the case anymore, and I have not worked for the commission to learn whether or not that second half was ever conveyed, but it wasn't. And so the commission has not received that extra 12,000 or so thousand acres promised to it. And I think the government's just kind of treated it as this is just land that we have to do other things with. But actually that was obligated to the commission, and I don't think there's been any change. It's just never been conveyed. I honestly don't know what's left of it, but I do know that there was 10 or 12,000 conveyed initially, with the expectation of another 10 or 12,000. It wasn't something they could do overnight, and so they were doing it as quickly, at least that was what was represented, as quickly as they could, and there was supposed to be another 10 or 12,000 conveyed. It doesn't appear that was ever done. I just learned that in the last few months.
If I may kind of pick up, I think what I'm hearing is you're replacing all available lands with all available Chamorro homelands. You're asking, is that going to limit us in the future if we want to move some available government lands into our inventory? So I think I hear you there. I think the reason why we stuck Chamorro homelands in to replace it was just so that we can ensure that we're remembering that these are Chamorro homelands. But I mean, being on Guam, is there any land that isn't Chamorro homelands? So, but then I guess there is the other definition of available lands, right? This land is available, and let's move it into Chamorro Land Trust property inventory. I feel that if we wanted to change that back to its original reading of all available lands, that I don't think that the commission would have any issue with it, or the other side, I'm sure.
I fully appreciate Madam Chair's concern, and I can see where that's coming from. Whereas before, Chamorro homelands was defined in the preliminary portion as referring to Section 75-105, which says, all available land shall immediately assume the status of Chamorro homelands and shall be under the control of the Chamorro Land Trust Commission. Now, all this does is compound the words together and says all available Chamorro homelands. It just skips a step and says, instead of available lands becoming Chamorro homelands, it says all available Chamorro homelands, which is not itself defined either, which is to our benefit, I believe, shall immediately assume the status of Chamorro Land Trust property. And it was in an effort to try and, as I said earlier, preserve an acknowledgement and appreciation for the history of these lands before they become Chamorro Land Trust property. But it does nothing to affect the characteristic of what are available lands. Because as Mr. Phillips indicated, they were arguing for a cap on lands. And we argued hard against it, and they conceded. If they hadn't, there would be a specific, explicit provision saying there is a cap on available lands coming in, and that's not the case.
I'm glad to hear that you were able to successfully remove a cap. All right, so the next section, 75101D, this removes the term Native Chamorro means any person who became a U.S. citizen by virtue of authority and enactment of the Organic Act or descendants. It replaces it now with eligible beneficiary means a person, regardless of race, color, or national origin, whose land was acquired by the U.S. between 1898 and 1968, or descendants, or who occupied, farmed, or ranched, and that land was acquired by the United States between 1898 and 1968. Any questions on that provision? This is really significant change, but I understand the rationale behind it, and I want to thank you for, it looks like an expansion of eligible beneficiaries. Questions? Senator Torres?
I'm not so clear on why 1968 was chosen. Do we expound on that?
I'm sorry, I didn't hear the question.
1968.
I'm just trying to understand the time frame and the rationale behind that.
Oh, the Davis?
Behind the use of the
1968
1968 time frame?
Yeah, 1968 came about in the discovery process when the United States asked when were the first lands taken and when were the last lands taken. If I was speaking to people, I'm very familiar with the history of Guam up to about 1952, but I believe it was Mr. Joe Borja that was researching that, and of course because of his experience with working with Bond, with Attorney Bond during the land claims, he had testified and I believe found that the last land taken by the federal government would have been 1968. And so actually the land takings, as they're called, if you go back to 1898, the different manners in which the United States, the term used is acquired, property actually went through 1950 all the way to 1968. But I do not know exactly, for example, what was taken in 1968 or how it was taken. I just know that was the evidence presented, and so that was the year that was used to cap.
Any other questions on that section, this section? Senator Paris? Oh, I'm so sorry. Senator Kelly Marsh-Tartino?
Sujus Masi, Madam Chair. So, even though some terms like eligible beneficiary are now being used, we've had some discussion and we can see here that the terms Chamorro and Chamorro Homeland were not something that were required to be removed. Am I understanding that part correctly?
Certain uses they did not find offensive, recognize that these are Chamorro homelands, as the chair explained. But their designation with the connotation that is their intent is the way they saw it. So if it's termed Chamorro homelands, it's kind of reserved for Chamorro homelands, and they felt, oh, that excludes a whole bunch of people based on race. That was their reasoning. As I said, though, it's important to understand both the context and the time frame here. You're literally talking within weeks of Davis, and so they were all thinking, aha, anything with Chamorro in it, quite frankly, is pretext for race. And the question we had, I think, presented to us is, do we risk the entire program because we find that offensive? I think everybody on our side found it offensive that we have to change these names, but at the end of the day, when we're choosing between that and risking that we're no longer able to continue the program because it's struck down in court, we all decided collectively that we would have to go along with at least some of those changes. We did our very best to educate them on certain areas. We prevailed. Other areas were just straight out negotiation and trading, and the areas that we were not able to prevail on and needed to concede, you find in front of you. Yeah, but that was after great debate. And I said, because I think a lot of people reading this, maybe most people might wonder why. And in light of Davis, that really is the best reasoning I can give. It's just the timing. Before that, most of this, I don't remember being on the table. It was just post-Davis. They said anything with Chamorro seems to be a pretext for race, and we're not going to agree to that. So that's when we started to split hairs, and we came down, somewhere in the middle with all the different terms.
And Senator, if I might add, there are, as I stated, 28 other references to the term Chamorro homelands in the Chamorro Land Trust Act that are unaffected by this and will remain.
And I think that's very important to highlight, that I can see it weaving in and out. Sometimes it's eligible beneficiaries, but those important concepts are still rooting, I feel, the whole concept of the Land Trust Act. And I too was reading it, that use of the term Chamorro homelands to refer to everything as homeland. Now, perhaps using other ways that we've seen Native Americans and others be treated, do you think there is potential without a definition of Chamorro homeland that there might be some way of somebody trying to come up with an interpretation? I'm reading it, it sounds like you're reading it as, well, of course, everything thus is Chamorro homeland, but do you see that there might be another interpretation if it's not defined?
Do you mean by keeping Chamorro homelands?
Well, by perhaps not defining it. I'm thinking, I know that archaeology has its pluses, but then it's also been used in law to try to have people who understood themselves to be descendants to now have to legally provide DNA testing that they are indeed descendants. And I'm not going in that direction, but I'm just thinking, I know we have archaeological sites, and so whether anybody might make some sort of case that, yes, we understand that ancestral villages were here, but in places where that were not ancestral villages, to just be protecting that term homeland for now and into the future.
Well,
Initially, Senator, there was no compromise at all regarding Native Chamorro, for example. There's no compromise. Davis came down, and there's a lot of compromise. That's just what happened. But there were our agreement, and I believe the intent of the governor was not to compromise on that for many reasons, and so there was none. And then Davis came down. I can't say which way the United States was going to go because they were reserving their right to amend what we kind of reached as an agreement. But personally, I think that would have remained if Davis didn't come down when it came down and how it came down. And so at that point, again, the question to us is, do we risk the program because of that? But obviously, we all knew it was going to be very sensitive, and we did our very best to explain to the United States why you don't want to come in here and just change all this. And I think they accepted a lot. Some things they didn't accept, and I believe some things they didn't have much choice because somebody higher up made a decision that post-Davis certain things had to give, and I think a lot of the things that had to give you find in front of you now.
Senator, I think the way it currently stands in the Chamorro Land Trust Act, the only definition, however slight, if you can even call it a definition of Chamorro homelands, are all available lands. But available according to whose interpretation is not defined itself. So I don't believe that there is any greater risk to a legal challenge. Doesn't mean that there won't be, but also in terms of principles of statutory interpretation, my understanding is that courts will look to the context of the entire act and be able to hopefully infer that it's simply a proxy for all available lands, and it's a cultural reference, but does not discriminate based on race, because what really matters is how the program is administered once it becomes the property of the Chamorro Land Trust.
Well, and I would say it would be a historical inference because it's based on the history of it, not necessarily the culture of it, if you follow my distinction. But I find it very reassuring that there are 28 instances where Chamorro homeland is in place. I think that's very important. And so that goes with one of my comments that studies show that when these terms and concepts are not readily a part of our public's consciousness, there can be a tendency for these concepts to be lost to the larger community. And I think it's really important that we keep those concepts, that history, that reality, that fact in our minds at all times, that it is a homeland, and it is, I mean, the way that I would describe the homelands, at least for me personally, and as an anthropologist, is it goes far beyond the land. It's the air, the sea, all of what was plied and used and occupied by those that were here before. And I think in this section, just to make sure that I'm staying on track, in this section, I think it was also very, very important to have those concepts be placed into here, the occupied, farmed, or ranched land versus a Western concept or other concept of owned, to be taken into consideration. These are traditional and cultural ways, as Attorney Phillips had mentioned, of connecting to and managing the land. And so I'd like to ask him, would you say that these concepts also take into consideration the historical circumstances that may have kept people from owning the land even after the system of Western land ownership was introduced? So in my mind, that makes it true restoration then, because there were various situations, it seems like, that were in place. So would you say that this also helps incorporate those historical circumstances that may have kept people from owning the land, be it traditional or cultural, but also maybe other circumstances?
Yes. And maybe 2 points there, Senator. One is, I was pleasantly surprised that the United States was agreeable, rather than go through the different manners in which the term they prefer to use is acquire the property from 1898 through, I'm familiar with 1952, but at least 1968 it appears. Rather than go through each one of those, that part of history, which is not very flattering to the United States, they agreed that's just carte blanche, everything. And so I was surprised by that. But I do want to just express one opinion, because of my research in this area. I covered a lot of the points that you've addressed. There really wasn't that struggle, that drive to own. There was a drive to work, but not a drive to own. So it's really, in my opinion, not as accurate to say that they were prevented from owning as much as they were displaced. And you don't have to look very far to see those examples. I was watching one of your sessions when Senator Terlaje talked about the relocation of everybody from Sumay. Where do things like this happen? And we expressed that to them, that things like that, happened on this island, and this is not normal. And we have different experiences like that, but from 1898 all the way through. I don't believe there's really that quest for ownership. It wasn't needed. And so it's kind of arbitrary to come back now and say, did you own it or not? Ask me if I farmed. Ask me if that's how I provided for my family. Ask me if that's how my ancestors provided for me. And the answer to that is yes. So I don't think, because that's just how things were, there wasn't so much that effort to acquire the property. They can honestly say, we didn't really block you from owning property. We displaced you often. We took a lot of your property. But I don't think there was so much a prevention from that, because it just wasn't anything that was really needed. That wasn't the measure of how you're doing. Of course, not too much afterwards, it became an incredible asset, even when it's not worth. Land had value, after the 1960s or the early 1960s, and things completely changed.
So just Masi for providing that further detail, because I think those are really important things for people to hear, and I think it really underscores how important it was to get those concepts in here. So I'm very pleased to see those concepts, and your explanations really helps us understand the value of them. Situus Masi, Madam Chair.
Thank you, Senator. Senator Paris?
Thank you, Madam Chair. So if I just could get some clarification on the qualifier for number 2, where it says, except that a person is eligible if he or she occupied, farmed, or ranch land on or after December 8, 1941, and the land was acquired at any time after that date up to 1950, or descendants of such persons.
Yeah, I can summarize, and then maybe Jamie will have points that we explained and they understood that it would be a little bit unfair to hold everybody to the same standard up until 1941. Post-41, when we had war and relocation that the senator talked about and everything else going on, so that requirement of using it for a year, ranching, farming, all that's really modified, and so that the time frame there doesn't exist anymore. And that's the best way I can explain it. But up until 1941, it would require at least a year of working the property, occupying it, using it. But post-41, through that very critical time period, they don't. My understanding of the settlement is we don't hold the individual to that time frame, to that minimum time frame. Is that your understanding, Jim?
It is, and of course, due to the upheaval caused by the invasion, Japanese invasion, the occupation, the liberation, and the relocations that occurred up until 1950. So that time frame, as Mr. Phillips said, is not used to penalize anyone in terms of counting whether they farmed, occupied, or ranched the land for a continuous year before it was taken.
So they could have just occupied for a day, and that would be considered as a beneficiary. Is that correct?
Essentially.
And I believe so, yeah. I mean, that would be our contention, yeah. I think the agreement speaks for itself, yeah.
Just a clarification, is there
Which
a
was not
sorry?
very easy to do back then, between 1941 and that time, yeah. I mean, so, but to answer your question directly, that's my understanding of the settlement with regard to that time period, yes.
Okay, thank you. And as far as acquiring, is there a definition for that, or what constitutes acquiring? The federal government acquiring
That,
land?
without doubt, is a term that was used, I'm going to say in my opinion, to avoid the necessity of explaining the different ways the United States took property. All the words have been used, stolen, taken, condemned, and more, I'm sure. So the word acquired is probably a nice way of recognizing that it went from an individual into the hands of the United States. And I know the main ways that happened, but rather than go through all of that, they just agreed to everything. Any land they acquired, if anybody was connected to that property, it was, as I said, that was another pleasant surprise that they didn't fight us on that.
Senator, I'm sure that during the time of the 1941 tax rolls, the naval government, in addressing some property owner who did not pay taxes, would say, well, you relinquished or you surrendered your property. We didn't take it because you didn't pay taxes on it.
They did say that.
Yeah, I'm sure. So that's an example of why that's an all-encompassing term, acquired.
Thank you. Senator Rijja?
So just to jump on that, off that line of thinking, so just to be clear, so that means that if someone's land was acquired they relinquished it because they didn't pay their taxes, then they would be eligible?
Yes,
Okay,
definitely.
thanks.
Senator Taitigui? On this provision, eligible beneficiary. All right, thank you for those explanations. We're moving on to 75105. Any questions on that? We kind of touched on it earlier. And I'm satisfied that you understand my concern there. All right, we'll move on to the next one, the verification of eligible beneficiaries. Any questions? Comments? All right, Senator Kelly Marsh-Titan.
So I'm not extremely familiar with what was in place in the past, but I thought it was important, again, to have that flexibility in here. There are a whole variety of reasons why somebody wouldn't have documentation to show usage of ranching of or ownership of land. And so I thought the flexibility that's in place now, if not in the past, but that's in place, is really important. And so I was pleased to see that was there. I think it goes back to maybe there are a few more steps, but at least it strengthens it by providing that flexibility.
Thank you, Senator. This, the big challenge, I think, to me is that although we might be expanding those who are eligible, they are now going to be required to sign an affidavit. And it's just my experience with people, because I'm a lawyer, that they're shy to sign affidavits, and it's going to take a lot of education on behalf of the Commission and the government of Guam and the Attorney General's office, hopefully, to just assure them that this is, to ease them into this process. I want to note that, so it repeats the verification process and who's eligible, but on the part where it talks about the occupied, it says here, occupied, ranched, or farmed land for a continuous, substantial period of time as of the date of acquisition. And if you go back to where we just came from, the eligible beneficiary, it says occupied, farmed, or ranched for at least 1 year immediately prior. I think you need to clarify that.
Yeah, that's for example, if somebody had done that and was not using the land, and then then the United States took it, then that individual hypothetically would not qualify. So that somebody that, obviously they're a descendant of somebody that lost their land, who at the time that they lost the land either owned it or used it in one of those ways, by occupying, ranching, or farming.
No, my concern is, in one part you're saying for a substantial period of time.
That's defined as at least 1 year, yes.
And the other one says for 1 year.
Well, no, I believe somewhere in the agreement that is defined as at least 1 year.
So substantial is defined as 1 year.
It is. Can I
Oh,
direct?
later on?
It
Okay.
is.
All
On
right, then.
Page 3, the second
Okay, great.
indented block
So they're
paragraph.
consistent. Okay,
They are consistent.
thank you. And any other questions on this section? Senator Torres?
Attorney Canto, as I'm reading this new listing of verification of eligible beneficiaries, it seems like there are many, many steps that one would have to demonstrate, and the mechanism or the submission would be ultimately an affidavit signed under penalty of perjury. But what I am considering right now, as I think about the practicality of all of this, is that we're talking about a time period between 1898 and 1968, a period where most of the people that have any knowledge of what actually transpired during that era are either aged, very, very aged, with limited mental faculties and memories perhaps, or deceased. And so how do we run the risk then that we really have a system that we're going to put in place that has no ability to verify whether in fact the person submitting the affidavit is perjuring themselves? Because there's no test if there's very few records. And I know just in a practical experience with ancestral lands that are unrecorded, or not surveyed, the proof is an extremely big burden and hurdle to overcome. So how in your estimate as an attorney and a judge, how do you feel about that? I mean, is my concern reasonable, or is that also going to possibly pose a bigger burden on the land trust because you can't, it's difficult to verify.
Yes, Senator, and I'll allow Mr. Phillips to correct me, but to answer the Senator's question, the concern is reasonable. I think that we were able to address it here with language, because the requirement is that the information be given, but as stated, to the extent known or reasonably ascertainable by the person, because there's an understanding that there is a strong oral tradition on Guam, and that there are strong family bonds and extended families for which there should be, or is known to be, a family historical record that is tied to land, either owned or used. And that's why it's only to the extent known or reasonably ascertainable that the person can come up with the information. Elsewhere, it states that the applicant shall be required to use their best efforts, to do their best to obtain the information. And that is to track down whatever aspects that are asked for, whether in the context of ownership or land use rights. So then, once an applicant fills out to the best of their ability, having taken reasonable steps to ascertain that knowledge, well, if it's not through written record of land ownership, then it's through learning about their family's history as tied to land here on Guam. Then it's based upon the review of the declaration or affidavit, the commission decides whether this is sufficient upon which to issue a lease under the program. So I believe it does balance both ends of the spectrum in terms of the uncertainty of information, but also and the ability of an applicant to do their best and to do what they need to do to provide as much details as they can, and then as well leaving that within the discretion of the commission to decide if this is sufficient enough by which to approve the application and issue the lease. I don't know, Mike, can you articulate that better?
I just believe, my thought, and I appreciate that, and I can see the effort, and, it is quite hard, and it seems that it would pose more of a barrier than an opportunity in a practical sense, because I also am aware of situations in having intimate knowledge of certain circumstances where it can take over 30 years for an estate to be closed. Even in a state where land is known and all the records are in place, it's a very difficult test to prove things to the best of your ability. And then there's no real way to ensure or ascertain where there's very effective fraud involved or truth to applications. And that's where I'm getting at. We want to service as many as we can, as best as we can, but we also know that if there's an ability to just, to the best of your knowledge, 1968 is a very long time ago, and we also know that families on Guam are very largely displaced right now. Many have moved off. Many of these applicants or eligible applicants no longer live in Guam, and there's generations following them that have never lived in Guam. So that ability to meet this test is a lot harder than it seems. And but what concerns me is whether we can ascertain whether perjury is being committed, and I'm just very uncomfortable with that.
If I may, Senator, one requirement under this agreement would be that the commission, in making their decision, would have to, at the very least, consult the John Bond files to see if that property is already accounted for in terms of ownership by another property owner.
And that's the record of condemnation, correct?
Correct.
Okay.
So there's at least that check to provide or to prevent fraud, that they'd have to be verified to the extent that it's cross-referenced against the John Bond files. Mike, did you have anything to add?
In addition, there will be There is a existing database, but there's as it proceeds, there's a compilation of knowledge. For example, somebody shows up and is a descendant of somebody from Sumai. I think the questioning ends right there. Somebody, lived in what used to be called NASTs and places like that. And the more information the commission receives, the more I think they're able to fast track people that automatically qualify. But yeah, definitely there's more work and more detail needed because in order to now pass constitutional muster, as they say, it's land restoration, and so there has to be some connection shown to the land. The benefit we have is we know that everybody was connected to the land. The challenge, of course, is, well, in their words, well, if that's true, then you guys shouldn't object to having to at least have a prima facie demonstration of such connection to the land, and so we had to accept that.
Senator, it's, like I said, it's the balance that was struck between, say, the difficulty of an applicant to be able to come up with these details versus the concern to prevent fraud. And this was the balance that we believe was the best one to strike.
Yes, thank you. And that's exactly it. I'm thinking about how difficult this is on the one hand, and then the other hand is if they accomplish that, how the difficulty of verifying. So no, you're absolutely right. I don't misunderstand that issue. It's just understanding that we're talking about a long time ago, and many people no longer existing who can verify within the familial structure. And that was just my point. And it's just a reasonable concern, and I just thought that I want to raise it so that you could echo some of the things that I was suspecting about, how this is going to play out. But thank you very much. I appreciate your candor.
Thank you, Senator.
Thank you, Senator. Any other questions on this provision? We'll move on then to the last provision for language changes, which is this is the life estate for a spouse of 7 years who was residing on the property and is not an eligible beneficiary. Any questions on this provision? I noted, Chairperson Farrer, in your press release, you note this to be the compassionate portion of the settlement agreement. All right, Senator Marsh-Tarcino, question?
At this point in time, I just have a simple question, or I think it's simple. So I was looking at the 7 years that the person needs to have been married to the lessee for at least the past 7 years. Does anybody have an understanding of how that 7 years was arrived at and what the reasoning is behind it so that we can understand that?
Well, I know we tried for 10 years. We were concerned also about fraud. Maybe some of our leaseholders would be taken advantage of if they had a home. So we tried for the 10 years. They actually came back to us for 4 years. So we compromised and landed on 7. But I believe that we first started off with the 10 years because a military spouse is not eligible for benefits unless they've been married for 10 years. Is that right? I think that's where we got the 10 years from.
Great idea. Good idea.
Yeah, that helps provide some reasoning behind it. Right, with the 7 years, and I was thinking, there are those terms like the 7-year itch, and so is it related to that anything less than the 7, that it's that 7th year that's key. So I think maybe from that standpoint, I don't know where those studies are on that particular year anymore, but at least it helps me understand. And then I was also trying to relate it to, and I believe we don't have common law practice here, but I think that's often associated with 5. So, but I can see the compromise between the 10 and that there is another standard that utilizes 10, and wanting to make sure that it was indeed a real relationship, and then this 4 and coming up at the 7. So thank you for that clarification.
I want to ask one more question on this. And so this is for a person who's named beneficiary, named to succeed the lease.
They have to be named.
All right.
Earlier, Senator, the negotiations were such that that provision was there, but they did not prevent us from ensuring at the beginning that only qualified applicants are named. But in good faith, we pointed that out to the United States, and they said, oh no, our intent is to ensure that they be able to designate somebody in that situation. And so rather than have that conflict come up later, we pointed out that if you don't change the beginning that allows for that designation, then that's meaningless. And so that's where we negotiated, because at the beginning, our provision would have been not to provide any exceptions to the act, just like the
For
Hawaiian
an
Homes Commission Act.
ineligible
If you're not eligible,
beneficiary.
you're not
Right.
eligible. Yeah,
Right.
it's your choice to come or not, or to use the property, but you must qualify, and anyone who receives it. In the Hawaiian Homes Commission Act, I believe in the Chamorro Land Trust Act also, if you were to depossess somebody, the commission would have to pay. So it's not like the person just thrown out. I mean, if that's their property and they're not qualified, then the commission would have to pay, I believe. I know it's that way in the Hawaiian Homes Commission Act, because there's no compromise in the Hawaiian Homes Commission Act, but they don't just acquire a house for free. They would have to pay the market value of the house. So the individual, while having to leave, would leave with the value of the property. And so that's considered equitable. And here, though, there was a great interest in what the chair has described as a compassionate exception. And this is one of those areas that was very, very important to them. And again, we were faced with the idea that there's two ways we look at this. One is, I believe we received concessions because we went along with this. And number two, it didn't appear to me that they were going to go along with settlement period without this modification. And we faced the possibility of risking the entire program rather than give in. But for the record, I believe both Alaska and Hawaii do not have that exception, and we have not had that exception.
They were not
before.
forced to make an exception.
No, they were not. In fact, their language is very clear with regard to how they handle a situation, and it's a very clear prohibition in Hawaii.
And is it also correct that my understanding is that this provision would not resolve the original question that came before the court, which was an ineligible beneficiary was not named
That's
as
correct.
the designee of the lease.
That's correct.
So this is a different case than even that one. And so
That's correct. And for the record, Madam Chair, and the Chair and others may want to comment further on this. I'll try and keep my comments short. But the allegations were unfounded. And we dealt with the face of the law, and with the understanding that we were going to have to deal with the allegations, the factual allegations later. But as time went by, it became apparent, I think, to everybody, but definitely to those on our side, that those allegations were just false. And the commission did none of those material acts that they were charged with. And so what the United States, I believe, was faced with was arguing that the program itself is unconstitutional, but I don't think they were going to get very far with the allegations that involved, or the allegations surrounding the commission's implementation and operation of the program. Those are just unfounded. Yeah, but you're right. There was some similarity with regard to that allegation that somebody was just thrown out. That person was not named, and the facts we received later were in fact. Make it very questionable whether there was any interest in having that person take over the property. It just doesn't appear there was any. Yeah, mm-hmm. Not a very nice situation internally with the family, but that happens outside. And last but not least, Madam Chair, the initial proposal was to have that last portion resolve the remaining interest through probate. And we argued against that successfully and said, no, this should go back to the commission. And so it comes right back to the commission as it is in the Hawaiian Homes Commission Act and as it is with our other provisions.
thank you for that. Mr. Canto?
Just to add on, I think, and when we did raise the factual variance, The counter argument was, well, wouldn't this be a benefit to the eligible beneficiary that they would want to have? That they've built a home in which their spouse of a substantial period lives, longer enough, hard to quantify, albeit, but longer than what would be deemed a sham marriage. And then that person, although they are not otherwise eligible themselves, would end up being evicted. And that's what it came down to. And we went back and forth, took out the probate aspect, made sure the property reverted back to the trust. And it'd have to be a primary residence. It'd have to be an approved residence, ostensibly meaning there's an occupancy permit issued. I just wanted to give a little more context about why it was we arrived at where we did.
You mentioned Alaska and Hawaii and how they were not forced to make these exceptions. What about, does this relate, like in Samoa, where American Samoa, they have a provision that only those of American Samoa, I don't know if it's descent, can own land? And are they forced to allow exceptions for spouses? Are you familiar with that?
No, I'm not. I'll check though, Madam Chair, and I will send the committee a note, my findings. My understanding is this is the only exception that I'm familiar with. It was kind of carved out, and I'm not sure if you were intimating or stating directly that, as I believe, it must be some way of and I don't mean in an offensive way, but saving face, because those are the allegations, and you know the case started like that. There's a little bit of reflection here that maybe arguably that as a result of that there were some changes that give them a sense of comfort.
Yeah,
Senator,
I understand.
I'm
Yes.
sorry, just to answer the Madam Chair's question. My research indicates that the aspects that you're alluding to for American Samoa were made a part of their Organic Act, essentially.
Correct. Yes.
By an act of Congress.
Congress.
Same with the Hawaiian Homes Commission Act, passed in 1923.
Right.
By Congress.
That's why they're not
that's the difference.
forced to make these exceptions in litigation.
That's correct.
All right. Which, of course, we all have compassion, and so I understand how you reached this. It's just that when we start off saying this is a land restoration program, based upon past injustices, it doesn't seem to match in the end. But that's just this one provision, and I understand how settlements go. So I want to thank you for your work. Again, the last couple provisions of the terms are not necessarily changes to law that you're suggesting, and these are just what you have agreed to with them. But if I may, is there any question on that the Commission will make reasonable efforts to notify current lessees and applicants of the provisions of this settlement? Any questions on that? None. And with 180 days, the CLTC is going to be trained in the Fair Housing Act. All right, I'll leave that to you guys. Thank you. Mr. Hattek, you're going to have your hands full. Number 4, this is the one I have questions. The duration of this agreement shall be for a period of 4 years. We're talking about this settlement agreement. During this period, defendants shall maintain all records with respect to compliance. The U.S. shall have the right, upon reasonable notice, to review and copy any such records and to take any action to enforce this agreement for 4 years. What happens after 4 years? We've already made, presumably, the legislature will have made changes to the law, and then what happens 4 years later? Mr. Canto.
4 years later, then, pursuant to the agreement, the United States government could not do anything to intervene in the program as it stands at that time. What is contemplated during those 4 years is that records would be retained, which the Commission would do anyway, of all applications, and the Department of Justice, if they so desire, may ask to see them or some portion of them, and ensure that essentially there is no rubber stamping. If someone out of a list of 7 criteria comes up with 0, and they're still issued a lease, this alludes to Senator Torres' concern, there might be some concern on their part. And I think that's that expresses the intent of that provision.
I understand some of what you said, but when you started out and said that the U.S. would not be allowed to intervene after 4 years, I guess I just don't read it that way. I mean, but you've been assured of that?
The settlement agreement, the details of the final settlement agreement are shaping up essentially to intend that the case be dismissed. And I'm going to engage in more discussions with Mr. Phillips on this. They could file a separate action to enforce the agreement, but not after 4 years' time, by definition of the language in the agreement itself. And that's what I mean by they wouldn't be able to intervene in terms of these facts or upon whether or not we are complying with this agreement at that point.
Would we be able to negotiate an additional provision that the United States is not authorized after 4 years to challenge the provisions of the act that were changed pursuant to this agreement?
That's inherent in terms of, as long as the amendment of the act conforms to the points as we discussed today in the term sheet, there would be no reason for them to do so. They would accept at that point that's happened within the time frame given, the 1 year from the signing, and once that occurs and they haven't had any objection to the act as amended, would not be able to take any legal action based upon the agreement or the administering the act according to the legislation as intended to be amended.
Right, but after termination of this agreement, which is 4 years, I'm saying after that, are they able to come back again and do the same thing and challenge the exact same thing, I guess I'm asking?
I think in the final
Mr.
agreement,
Phillips?
Senator, it might be prudent to,
Number 6.
to address that. I haven't seen a draft or anything of anything after this, but I don't think there's any harm in us requesting for that admission and clarification.
Yes, so the Senator Torres is suggesting, would it be clear that this is like a consent decree settlement agreement, you know, or
That was the original
the
intent.
parties would?
Is that be a consent decree? Because we wanted to use it as protection for whoever comes next and say, no, the court has already ruled that under the current language as amended by the legislature, it passes constitutional muster.
That's what I want to hear. If you could please give us your assurance after today about that point.
I can give you my assurance that was the negotiated and that was the intent, but I haven't seen anything. It's not specified in here, and I have not seen a draft yet of anything further. So that's the limit in which I can give the assurance. But I agree with you, Senator.
All right, Senator Torres.
Yeah, thank you, Madam Chair, for bringing up that point, because what we're doing here is we're agreeing to something that is only as good as we're able to comply to their satisfaction that we've complied. And so that, you know, in essence, it is a consent decree, because until you can demonstrate to their satisfaction that we've met all of their criteria, there really is no settlement in its entirety. And that's what I gather from there. I don't have any objection to it necessarily, but it just puts the terms of this settlement into perspective. Thank you.
Thank you. Yes, I would just, again, want to reiterate, if we are going as a legislature and the government of Guam to agree to change our statute to remove the term Native Chamorro, to extend this to be compassionate in addition to land restoration, I'm hoping that we can get some affirmative,
Finality, yeah.
yes, that we are not going to be challenged after we make these changes to our statute. Thank you. So number 5 is the only remaining one. I think it's, well, that's you're promising that your agreement that you've signed is contingent upon legislative action. And I appreciate that, because we're making changes to the statute. What other action do you foresee by any other party in Guam besides the legislature, Mr. Canto?
Sorry, I don't foresee any, simply because the rules and regulations of the commission, which are the possibility for which are anticipated by this agreement as well, are at this point codified. So if that continues to be the case, then I don't foresee any other executive or commission action as contemplated.
who needs to sign the final agreement? Would it be the attorneys, like who signed the term sheet? Or would it be, for example, the chairperson of the commission, the defendants themselves? Who would sign the actual agreement that you say you're working on?
Well, my understanding, and I'd also defer to Mr. Phillips on this as well, my understanding it would be the attorneys who sign as to approval as the form, essentially, and then the defendants, as mentioned, the chairwoman of the commission, the administrative director, who are named defendants, and on behalf of the government of Guam, I imagine it would be the chief executive officer of the governor of Guam. Does that sound right to you, Mike?
You know, I'm not sure if the governor did not intervene.
On behalf of the government of Guam?
Right. Yeah. So I don't know. I don't think that would be improper. I think that would be that would give everybody a sense of comfort. I think the United States would want that.
Yes.
Yeah, and they definitely want the named defendants. Somebody's got to sign for the government of Guam.
Yes.
And that it's likely that quite naturally would be the governor.
All right. Well, Mr. Canto, if you could keep us informed if anything changes as versus what you just told us right now, then
In terms of what specifically, or
just
everything?
who the parties would be that sign off on the agreement and that type of thing.
Certainly.
For the commission, you have so much work on your plate right now, and so I feel for the commission because this adds another, stack of work, I'm sure. But I do appreciate your focus on the intention of this program and sticking to that as much as possible and allowing it to continue despite the huge amount of work. And do you believe you will be able to implement this? I know, Madam Chairperson, that you did say that the commission members, you're confident you'll be able to put in the work to implement this if the legislature was to change the law? And Mr. Hattick, what do you think, what do you expect on the behalf, as a director, the work that might come about from these types of changes to the law?
Thank you, Madam Chair. Yes, I look forward to looking to the commission and working with them and their guidance on the exact implementation of this. I just want to point out that with regards to any specific amendments, the resulting expansion of the eligibility will in all likelihood create a need for the hiring of more personnel at the department. So I'm just wanted to point that out, that it's entirely possible that we could do that, and I would like to work with the commission and the legislature to make sure that that happens.
Any chance that the United States might agree to help us survey the properties as well while we're at it? You never know. Anyways, any other final comments by any of my colleagues? Senator Perez.
Thank you, Madam Chair. I just have a question about the agreement. So it says about how damages for aggrieved persons under the Fair Housing Act will be barred. Are there other aggrieved parties out there that could potentially weigh in on this?
None that I'm aware of, but of course the commission might have personal knowledge of any complaints, but I personally have not heard of any in this litigation.
Is there enough protection from that, from potential another lawsuit? I mean, because when we talk about class action lawsuits, there's some parties that don't join it necessarily. So I'm just
right. And in this case,
the
alleged aggrieved parties were not part of the suit, so they're not named either. Factually, there's reference, but they're not part of the suit. So they didn't bring the suit on behalf of those individuals, though they did reserve their right to ask the court to impose damages, and so they kind of explain it in that way, where they didn't bring suit. I think they can, and I think they have on behalf of individuals, but they didn't in this case. Factually, they made allegations, and they did ask that the government of Guam put some money up, but they could not substantiate the facts. And that was just another point that would, in my opinion, was non-negotiable. We were not going to negotiate that away. We had won that in the motion, and there didn't appear to be a time that the government was going to give anything.
Senator, the intent of all parties, even those on the other side of the table, was in terms of crafting what our proposed amendments to the legislation was essentially to prevent any further cause or basis for a challenge of racial discrimination. And for that reason, we don't foresee any repeated allegations of that nature.
Senator Rizzo.
Thank you, Madam Chair. Just one sort of last question. Obviously, you guys have worked hard on this settlement. You've taken a long look going back and forth over the terms of the settlement. I guess for the public, can you explain to us what's at risk should we not accept the settlement, and what is the risk should we not accept the settlement?
I can summarize. It's important that our people know that we prevailed in the first round, and I think the United States was very surprised by that. I was pleasantly, I wasn't surprised we prevailed. I was pleasantly surprised by the extent to which we prevailed, and the understanding that the judge had with regard to our arguments. I've raised similar arguments since 1992, and quite frankly, even on Guam, some people don't understand how it works. The judge not only understood, but she was able to craft an order that made it very clear, I think, to everybody concerned that if this was a land restoration program, and Guam was able to show many reasons why we don't have a stack of papers ready to prove who owned what, and it's no fault of our own, and it could be things like war, typhoons, relocations, things like that, all kinds of reasons why the Chamorro Land Trust Act is the most efficient way to accomplish that land restoration, and she wasn't going to set it aside. And so we had the benefit of that wasn't the beginning, but that was a kind of first base. It was a great start. So we started off by prevailing on ensuring that the government didn't suffer financially, and that's a big risk, and it can be very, very expensive. And secondly, that if we were able to show what we believe the program was, in fact, that's one of the things I said from the beginning was, gosh, all we have to do is tell the truth, because if we tell the truth, we pass that test. None of that existed at the beginning, and the risk, senators, that while I'm fairly confident, that, you can never make a prediction with too much confidence in court. I was confident we were going to prevail in the district court. Obviously, I'm not as confident with the Ninth Circuit or other courts of afterwards, and maybe even other cases with different judges. This judge truly understood. She's from Hawaii and truly understood our history, was able to read things and understand it because of her background. Most times, people look at something and they're looking at the same history, the same documentation. They see it a very different way. And so I wasn't very hopeful with the Ninth Circuit, and would not have that same optimism with another judge in another time. And with a great opportunity to insulate the act from attack, Jamie's right. Both sides were, in essence, trying to do that, because they were saying, look, these are the problems we have, guys, and you got to get rid of these. And we were, at the same time, trying to preserve as much of it as we could, but with the whole idea that we got to keep this in place. I said to people many times, God forbid we hold strong on one argument, we end up losing the case, and then somebody very soon looks at what we did and says, you risked the entire case because of that? And there's very few points that could pass that test. That is it really worth risking the program because of that one item? And because of that, I think we all kind of rallied around doing everything that we could to keep the program in place, and at the same time trying to keep the integrity of the program. We're very fortunate to have the individuals that appeared on behalf of the United States. In my experience, I've never had attorneys on the other side that I believe were dealing in good faith and really trying their best. That's another thing I don't think don't mean to say anything bad about the U.S. Attorney's Office or those from off-island, but they're a rare group. I mean, this group, I don't know how Jamie feels, but they're really, we're very fortunate to have those individuals, and they took the time to understand and do their best. That's another element of a case I don't think we would have again. Is the attorneys assigned to this case, we're very lucky that they were open-minded and wanted to understand.
Senator, in terms of the risk that we face if the legislature does not adopt these aspects of the term sheet, is essentially what we stand to lose if the Ninth Circuit does not go our way. And given their ruling in the Davis case, it's a risk that we can't ignore. And while there are factual disagreements on both sides, I think the stakes are high. If we lose the case ultimately at trial, it would mean a complete invalidation of the program. That means 8,000 people currently standing in line applying for leases would have to no longer be in line and go home and have nothing to show for it. The 3,000 families currently living on Chamorro Land Trust land would have their leases declared invalid. A judge would force the government to essentially evict them, and they would be homeless. And that's what I think about when I think about what's at stake here.
Thank you.
I'm smiling because there was a Facebook post by an attorney, Oliver Berdalio, who is the son of Paul Berdalio, who was the author of the Chamorro Land Trust Act, who said, eviction, let them come and try to evict us. But, and I feel the same way, and all joking aside, I wasn't really that joking about the surveying. What we're doing here is we're agreeing to a settlement in litigation for a land restoration program that the government of Guam put up. We put up a land restoration program for the people of Guam to restore land that was taken not by the government of Guam, it was taken by the United States government. So the theme kind of rubs me the wrong way. I totally get all the work that you've done, but the overall, I just don't want to lose sight of the big picture here. The big picture is that we put this program up to restore some kind of justice that was not being brought to the people of Guam. We ourselves tried to do that for ourselves, just to restore a community to thrive, to have a place to live, call their home in prosperity, right? And so we are now looking at, I just want to make sure that in this settlement agreement, we in no way relieve the United States of any responsibility to return the land that they have taken, to restore justice to the people of Guam that they have put the injustice on. I mean, I don't want the Manamkut to tell me, hey, you guys just settled for me it's an injustice. And please don't let anything in any settlement agreement that you're going to come up with waive that responsibility on their part, that they don't need to come up with a land restoration program of their own because they're, or that they don't need to return the land anymore because of our land restoration program. Please, I want to make sure that we're relying on you attorneys to do this for us, and please make sure that that's not what we are doing by settlement.
There was some discussion, Senator, about the different programs, and it didn't go far, but we made sure that there was no reference at all to people that may have benefited from land returns or people that may benefit in the future. And I totally understand your point. It reminds me of the people of Guam having to pay for their own war claims.
Exactly.
Yeah,
it is
just,
exactly that. And then they come and tell us how to do it. So that's what we're doing here. And so please, if you could get it in an affirmative language, I think that's even better, that nothing in this settlement agreement, affects the rights of anyone on Guam to be restored by the United States, or nothing in this agreement affects the demand of the people of Guam for return of the land by the United States. Senator Torres? Senator Torres? Senator Kelly Marsh, I'd like to know. Thank you very much. Thank you again for all the work that you've put in and for keeping us informed of this. Thank you to the commissioners especially. I know this is a big burden on you to go through this litigation. You've been sued. No one likes that. People have resigned from boards because they've been sued and their names get put in the newspaper as if they've done something wrong. And I want to thank you for doing something right and standing up for us in this case. And please continue to stand up for the people of Guam. Si Diyos masi.
Thank you, Madam Chair.